Number 4, Bank of America versus Kessler. Counsel?
Thank you, Your Honor. Good afternoon. I'd like to reserve 3 minutes for rebuttal.
You have 3 minutes.
May it please the Court, my name is Suzanne Berger, and I am here today for the Appellant, Bank of America. The question presented is whether RPAPL 1304 prohibits a lender or servicer from including in the 90-day notice, quote, additional material, close quote, germane to the purpose of the statute, i.e., material that will further bridge the communication gap between the lender and the borrower facing foreclosure.
So how would a court determine if that's the case with a particular item included in this envelope?
It would, whether it goes to the fact that the borrower is in default. Here, the notices are...
Well, assume the borrower is kind of in default, that's why you're sending a notice, right? So what can you put in there? What's the test?
The test is whether it further helps the borrower and doesn't undermine the purpose of the statute. So, for example, here we have, as one example, the bankruptcy disclaimer, so that it tells the borrower if they have received a discharge in bankruptcy that this is for information purposes only. That's integral to the notice so that the borrower receiving the notice doesn't misunderstand what the notice is trying to tell that person.
Does this rule create a series of ad hoc disputes over whether it meets the requirements of your rule or that it's extraneous, distracting information?
I don't think so. I don't think so for 2 reasons. One is we've had this rule for 10 years, and until the Kessler case came down in Westchester in 2017, there were a few minor cases, but we didn't have that as an issue. It wasn't being contested. Everybody understood that as long as the notice was in the proper size font and contained language that was required, and remember, the statute says shall include, so the legislature knew that there might be other things that were germane. I do not see satellite litigation growing from this. In fact, if the court were to say, yes, you can have a Fair Debt Collection Practices Act disclaimer, the mini Miranda, which some courts post-Kessler have said is a problem with how the Second Department interpreted Kessler because it doesn't allow for what's required by federal law. So if this court were to say
Judge
compliant...
Marrero said that, right, in the Southern District?
Judge Marrero, yes.
So if it's so widespread and everyone appreciates it and understands, then why do we need a separate envelope requirement?
I believe the intention was not to put what I'm going to call regular periodic notices in. In other words, it shouldn't be enclosed just with the monthly mortgage statement or the escrow analysis you get every year, or that the bank's offering a toaster if you make, open a new account, that it's only for information focused on the issue, which is that the borrower is facing foreclosure if the default is not cured within 90 days. And these are various ways the borrower can be assisted. They can go to one of the housing counselors in the region, that is part of the required notice, or if they're a service member, for example, they can call the number that's listed in the additional information provided in the Kessler notice and get additional help because service members have additional rights to delay litigation when they're overseas.
Do you know whether the bank had a concern that the 1304 notice without the bankruptcy disclaimer might be viewed as an interference with an automatic stay?
There have been cases that have suggested that, yes. And that depends on the facts and circumstances, but throughout the nation, courts have said if you have the disclaimer, that's a safe harbor for the person sending the notice, and that alleviates confusion. And so, yes.
Is the standard strict or substantial compliance, or do we even have to decide that?
I have an opinion about the answer, but I don't think you have to decide that. Meaning, I think we can presume that you need strict compliance in the sense that a 1304 notice must be sent to natural persons and other people having home loans, and so that has to be strictly complied with. The language of the notice can substantially comply, I would argue. I don't think you have to get there, because I think this one does comply, given the shall include language which is non-exclusive. The substantial compliance standard would be helpful in perhaps some satellite litigation, but I don't think it's necessary for this notice to make that decision.
If this is affirmed, can you refile after dismissal under the provision of the CPLR that gives you 6 months?
In this case, I believe one could, unless it was dismissed, for example, for delay in prosecution or one of the other reasons that are not allowed under 2005, CPLR 2005. And, this default was in 2013. It's taken a while to wind its way through the courts. The appellate division sat on it for over 2 years. So I can't tell you for certain that some judge might not say there's been delay for that reason and prohibit it from being refiled. I would hope not, based on the facts of this case. I see my time has expired, and I have 3 minutes reserved for argument, unless somebody else has a question right now.
Thank you.
Thank you.
May it please the court, Charles Walshine for the defendant, respondent, Andrew Kessler. There are two things I believe that's squarely before this court. The first is the strict compliance standard required by 1304, and second is, does this statute accomplish its purpose?
Where does the statute say it may only include certain language?
Well, that's the shall language, Your Honor. There's two parts. There's the 1304-1, which identifies...
Is shall inclusive or excluding?
Well, it includes the language that's provided in the statute, and in 1304-2, it says only this in no other envelope. In other words, this is the single envelope requirement with no other
Section
notices.
2 says only this and nothing else in the envelope?
It says no other notices in the same envelope.
But doesn't that beg the question of what another notice is? And whether other notice is on a different subject or other notice is something different from the exact words in the statute?
This isn't the first time I've heard that. I've argued this.
Then you should have a good answer for it.
In this particular, in this context, you have to read the two parts together, and I don't believe that whether these other notices, in this particular instance, the SC, the SCRA, the FDCPA, the mini Miranda, and the bankruptcy notice, I don't think it's ever been litigated whether those are actually notices or not. The defendant, respondent, included the Black's Law Dictionary, which is an accepted definition of notice in the original brief, with the appellate division, and before that with the, at the trial level. And I don't think that issue is preserved for interpretation here. Not that, of course, this panel can't interpret what a notice is, but I believe that's issue's been resolved.
I guess I'm thinking of it this way. If I say my sandwich shall include mayonnaise and it shall be on a separate plate, I would be really surprised to get a plate of mayonnaise.
You might, but that's the reason I think we're here. It's it says nothing else, and and there these other things are. But I think the core, if this court wants to reach the core purpose of the statute, it's to essentially have the borrower, whoever receives the notice, to make a phone call or to reach out in an email or something. I need help. I'm about to go into foreclosure. That's the purpose of this statute.
So what if the lender put it in huge red type at the front of the required notice, this is really important, please read it? Doesn't strictly comply if you read this language as the only language that can be in there, but would you have a problem with that? Does that violate the statute?
Well, I think in 20-point print, I think it says this is, at the very top.
Yeah, 14, I think. But I'm saying if they add some extraneous thing saying this is really important, please read. It's not in the text of the statute. If they added that to those, is that If you want a strict standard, is there any exception to that?
Well, it's not a matter of, I don't think it's a matter of exception, Your Honor. I believe that when it says that use this language, I think the lender should actually use that
Right,
language.
but suppose you use that language and you add something else, and the something else, let's say, is something that is, it has no substantive content other than, this is super important, please read this, don't ignore this. But that's added. That's not in the statutory language.
No, I understand that, but if the question is, is there certain language that would be
No, I'm
more-
saying, would that void the foreclosure action, the inclusion of that language?
I don't know. And the reason I don't know is because it's not before us, and it's not really before us, and, you know, and I understand this is the nuance of this argument, right, is that there are certain things that would be more clear than others, like,
But I'm confused. If your argument is it's strict compliance, isn't the next step of that is, in response to Judge Wilson, if I'm understanding his question, that no, you can't add another single word,
Well-
not even a comma.
well, that's a little bit more clear, because you couldn't add a comma, because I don't think anybody would argue that a comma is a notice. But I don't, in this particular case, what's before this panel are these other three bodies of information that appear on the last page of the mailing. Do those constitute notices?
So if the court determined it was notices, then you concede that there's no problem, that there's compliance? In this case, on the facts of this case,
If these are not notices?
if they are a type of notice.
Oh, if they are a type of notice, well, they should be clear, there's no notices allowed, and these are notices, and it was in this, these notices were in this envelope, and they didn't belong there, I would say then the decision would be rather easy.
And if they are the type of notice, if I'm understanding your adversary's argument, that are permissible under 1304 because they are of the same, let me call it the species, as the notice that is set out as shall include.
Well, that goes again to the core meaning of the statute. I think the legislature realized early on that foreclosure there was a crisis, and it says so right I think the first couple of lines of the legislative memo.
Mm-hmm.
And this statute was designed specifically to keep cases out of the Supreme Court. And the thing that they did, and what the governor actually funded, and the legislature actually funded, were housing counselors that were foremost impartial. They were not the loan servicer. They were HUD approved, DHCR certified housing counselors. There's someone you could call. Now, keep in mind that when the statute was written, it had to be written for everybody. It wasn't necessarily written for Mr. Kessler. It may have been written for somebody who has extreme skill in something else, maybe a nurse who doesn't know anything about law.
Well, how do the additional information included detract from the statutory purpose? Or is that something we shouldn't consider at all?
Well, out of respect to the court, I mean, I will answer that. I mean, of course, I will say that it's not, that it shouldn't be before the court because the language is clear enough that you don't have to interpret anything. There's nothing extra this court has to do beyond reading the actual plain language.
Well, I might agree with you if it said shall only include, but since it doesn't say shall only include, we have to figure out.
That's the exact problem that Justice Miller identified in his dissent. It was 3-1 below. But if you read sections 1 and 2 together, which is the rule of statutory construction, you read the statute as a whole, it said you must have this, shall not contain that. Now, if we're all, as attorneys, we understand how to read these things, but if you put your mindset into your average borrower who's probably scared to death, they're starting to get, they may have already received an acceleration letter, and they're literally scared to death. They don't know where to turn. This letter says, call a housing counselor, you can save your home. They want to call that person. Now, you get a Miranda, or you call the loan servicer, the first thing you hear is this is an attempt to collect a debt, anything you say, and it says the same thing in writing on the note, on many of these notices. That's scary. And chances are you're not going to talk to that person. And this is written, and I think this was in my brief. I tried to really put a lot of accent on it. In the brief is that all these statutes, especially this one, is written for the least sophisticated consumer. It means it's meant to be understood by everyone.
What if an unsophisticated consumer didn't have internet and the lender, in what I would assume would be an effort to be helpful, went to the website and produced a list of housing counselors and included that with the notice? These are the housing counselors in your area. That's not a notice, obviously, so you can't include that because it's not strictly required?
That's on the that would be on the website, and that's got nothing to do with what had to be mailed by regular and certified mail to each borrower.
No, but I'm saying they know that the borrower doesn't have internet, so they're just helping a person out by giving them the information that they would get on the website.
I don't really understand that.
I'm just saying, they decided to print out the list of housing counselors and include that in the mailing.
Your Honor, there's a lot of things that a lender could do. This is what the legislature says the lender must do. And it also says what the legislature says what the lender cannot do.
I know, Counselor, but we're here to decide what else can they do besides what they must do.
Well, the legislature says nothing. And I think that it's clear, and I think that it serves a legitimate purpose, and
Well, under your reading, you would send out this notice only as set out in 1304(1)(1)A, right? And then any other notice, whether it's a type of point that Judge Wilson was making, or your adversary's reference, or what went on here, would have to be in a bunch of separate envelopes. How does that help the borrower, who is, according to these notices, a person who may be at risk of foreclosure?
you may be speaking, and please correct me if I'm wrong, to the Bright Line Rule. The Bright Line Rule, which I know you're familiar with because they're helpful. The Bright Line Rule here avoids a case-by-case analysis in front of different judges.
That may be helpful to the court. How is it helpful to the borrower? I mean, isn't that the point of the legislation? This is to help someone
They receive,
avoid foreclosure, at least be given assistance in a foreclosure proceeding.
yeah, that's absolutely true. But the question is what's helpful. The legislature decided that they wanted the lenders and the loan service to send one letter that says, this is how far you are behind, this is what's going to happen, could be within 90 days or at least 90 days, and we want you to call these people because it's going to, we believe.
What about an active service member who gets that notice without this one, the additional one, and doesn't realize for days until this other notice gets here that they may have a completely independent avenue to get relief here? How is that consistent with the legislative purpose?
Because they're receiving that notice in other mailings.
But it might come a week later.
Well, they haven't started the foreclosure yet. This foreclosure still hasn't started.
Your point about how scary it is to get a notice that says I'm a debt collector, isn't it scary to spend a week thinking I'm an active service member who, is now subject to this? I'm trying to reach one of these counselors and I have an independent government agency established to help specifically me?
Well, as Judge Schenkman pointed out, there's a way for them to stage their notices, for the lenders to stage the mailings. They could mail all of this other stuff first, and then mail this one, which says just include 5 counselors. This is how far behind you are. This is how many days behind you are, and call these. You have an option to call these five independent agencies to help you.
Could they comply with the statute by putting the required notice in an envelope, putting the bankruptcy and service person into a separate envelope, putting those 2 envelopes into a bigger envelope and mailing that? Does that comply with the statute literally?
I've been asked that question. I would say no, because it's still in.
Well, it's in a separate envelope from any other mailing.
Well, it's in the same mailing. If it ends up in the house.
It's a separate mailing, it's a separate envelope.
Well, again, I don't think that question's before us.
It is, I'm asking you.
Well, it's before me now.
Yeah.
I would say no, because it's in a single mailing.
Okay, even though the statute doesn't say single mailing.
It says single envelope, but it's like, well, there's a little envelope, there's one little envelope, one big envelope. Well, it's a good question, and I wouldn't know. I would say no, but again, not before us, and, I mean, I'm sure I could have researched something
I'm
about
just trying to
multiple
see how
envelopes.
literally you want us to read the words here.
I think I see my red light is on, but I think the decision ultimately from this court would be to look into the legislature's mind somewhat and say, what did they mean? And they want to help people. They don't want them to panic. They don't want them to do nothing. They want them to save their homes. Now, clearly, I believe that Judge Schenkman and the other chief judges, administrative judges for these, they spent a lot of money. They funded, they have in the basement, especially in Nassau County, they run a top-notch shelf there, show there. And what they do is the housing counselors usually carry the person through. They do the same thing in Suffolk. They do the same thing in Queens. And I'm mentioning these counties because those are the ones I'm familiar with. Also the same thing in Kings County. These people are helped all the way through the process. And the housing counselors, which is, I would hope, I'm glad I have this opportunity to talk about what they do, is they actually help people. And if anything, and I believe that the legislature believes, and listen, no statute is perfect, right? None of them are perfect. But the legislature says, accept this one literally, that we want people, and give it the purpose, and for this panel to read the purpose, call a housing counselor. Because we are going to keep foreclosure cases out of the IAS part. That's the ultimate goal. And I think this statute does exactly that. And to start wondering what would be and what would not be an acceptable notice, helpful or not helpful, you can send those in other envelopes.
Thank you,
You put them
counsel.
somewhere else.
Thank you.
Thank you very much, Your Honor.
A couple of points. One is, with the best of intentions, you can mail separate notices on the same day, and they may or may not arrive on the same day. So I think one way to look at what's a separate notice, to answer your question, is if you got in the mail the paragraph, the last page, page 7 of 7 in this notice, and it came all by itself, would you have any understanding of what it was trying to tell you? I don't think so. That's why it's not an other notice or mailing. Another notice or mailing is something that's complete
Well, that's because
within it.
it's written in a way that it follows, right?
Correct.
As opposed to, you could rewrite it in a way with an appropriate preface that would make it clear, no?
Yes, and in fact, lenders do send out separate notices to service members and so forth, but this is a reminder to service members that they have additional rights. And this idea that the legislature wanted you to call only housing counselors is not...
My point with that is, in response, in part to what you're saying, is whether or not the court says you can do this doesn't mean you have to do this,
That is true.
right? You could send it in a separate envelope if you wanted to.
Yes.
Unless there's a federal requirement that it be the first mailing and there's some other issue around that. But let's put that one to the side.
But there's a case that's part of the record where a borrower challenged as a separate notice the cover page which had the address of the borrower. And then the prescribed language was on a second page. And the court said, well, under Kessler, that's a separate notice because it has the letterhead of the servicer and it's the address. So that can't be we can't read the statute literally. We don't have to because it says shall include. And if the legislature wanted to say shall only include, they went back into session today, they can do that. I just want to pick up...
Let me ask you this. What if it said, I know it doesn't, but let's just work with this for a moment, shall give notice to the borrower in at least 14-point type stating, said nothing else, stating, or stating the following. We'll keep some of the language.
Instead of shall include.
Correct. What about that? Is that now exclusive?
I don't think it is exclusive because it doesn't say only. It might be closer to exclusive, but I would say no.
It's a hard argument, I think, for you to make on that one. Again, it's purely hypothetical, because that's not the statutory language.
Right, because it says shall include. And this, I was starting to say before that this idea that the legislature was focused solely on housing counselors is not correct, because the prescribed text requires the lender to include a phone number for the lender or servicer to contact as an option. It requires, in the required language, to include a phone number for New York State Department of Financial Services to call. So it's giving the borrower several options to avail themselves of. The last page of this notice gives more options. So it's hard to understand how that would be contra to the language. I think, as the court knows, you have
Does
to
it
look
matter
at...
that it's only one page and two other points? If you had 25 pages, would that somehow be undermining the purpose and intent?
It could, if the 25 pages had a lot of material that was not germane here. I gave some examples before. I don't think the number of pages per se is what's determinative. I think it's the content and whether it's designed to bridge that communication gap.
Thank you.
Thank you.